3, 2, 1. You are online.
Director of the Program on Information Justice and Intellectual. Somebody's saying they can't hear me. Am I not? I can't be heard. No?
I can listen to you now.
You can hear me now?
Yeah.
Okay. Okay. So then I will start. But my name is Sean Flynn. I'm the Director of the Program on Information Justice and Intellectual Property at American University. And I'm happy to be joined by several members of the Global Expert Network on Copyright User Rights. And it's just fantastic to be back at another iteration of the Global Congress. Thank you to Carolina Botero, to Viviana Rangel, to the whole Charisma team, and to Foundation ePharma and the CenterNet for Internet and Society at the University of Rosary, the Mission of Health in Colombia, and Internet Lab Brazil. Those are our main Latin American sponsors of this Global Congress. And so thank you for pulling on another, this time virtual Congress. This is our second Congress in the virtual environment. So I'm sorry we can't all be there in person, but I'm happy we could get together this way. So as I mentioned, this session is sponsored by the Global Expert Network on Copyright User Rights. And that network grows out of the first Global Congress on IP and the Public Interest, which was held 10 years ago, the 10th anniversary now. The first one was held August 2011. And that meeting convened almost 200 experts from 32 different countries to help re-articulate the public interest dimension in intellectual property law and policy. The meeting produced the Washington Declaration on Intellectual Property and the Public Interest. And that declaration contains a section on our topic today, and it was called, in that version, Strengthening Limitations and Exceptions. The declaration calls limitations and exceptions positive enabling doctrines that function to serve that IP laws fulfill their ultimate purpose, promoting essential aspects of the public interest. And it called for specific work, including on the issues we'll discuss today. So just a couple of those calls for work in the Global Congress that I think are relevant to today's discussion. First, it promoted discussion of employing open-ended limitations of exceptions in national copyright laws, in addition to specific exceptions. It promoted limitations and exceptions that enable libraries, museums, archives, and other institutions of memory to fulfill their public interest missions. It called for action to protect and enable teaching and learning at all levels. It called for action to assure the freedom of researchers to engage in large-scale text and data mining, or what it called non-consumptive research. And finally, it advocated for appropriate limits to the use of unfair contracts or technological protection measures that can override limitations and exceptions. So the Global Expert Network I mentioned was launched just a few months after the Global Congress, and its purpose was to continue work on a lot of those themes. And today we're going to hear from 3 members of the network who have been working on some of those areas in which there's been noticeable movement in policy just in the last year or so. So Dr. Carys Craig is the Academic Director of the Osgoode Professional Development LLM Program in Intellectual Property Law at York University in Canada. Will share her thoughts on a recent Supreme Court opinion on educational uses. Martin Senftleben, who's the Director of the Instituut on Information Law at the University of Amsterdam, will discuss some of the new provisions on both education and research in the EU. and Ueno Tatsuhiro, professor and deputy director of the Research Center for the Legal System of Intellectual Property at Waseda University in Japan, will inform us on some of the really unique legislative protections of non-expressive uses, really that almost using that exact term from the 2011 Global Congress Declaration for information analysis in Japan. I think we should have some time for discussion today with the participants of the audience, but if we don't, I will also share a Zoom room in which some of the speakers
Sorry, Sean, we aren't listening now. Please wait a minute. I don't know why you are offline. You can start again. Sorry.
Should I start again from the beginning?
No. You can continue. You can continue.
I can continue.
Sorry. Yeah.
Okay, Carys, we're over to you, I think.
Thanks, Sean. I'm glad I heard that bit. Hi, everybody. So my thanks to the organizers of this event for the invitation to participate. And thanks especially to Sean for all his efforts in bringing us together. I'm here to talk about new interpretations of Canadian fair dealing. And certainly the work that we're doing to show and to map exceptions and limitations show that Canada now has an open, kind of flexible exception for research and for education. And I think then what's important to understand about the Canadian situation is that this is not by virtue of having a statutorily open, general, flexible exemption like the US fair use doctrine, but rather is just the result of an evolution of fair dealing in the Canadian courts. So an evolution from a rigid, narrow defense to a large and liberal one. And that evolution, I think, has been solidified now by the Supreme Court of Canada's ruling in the York University and Access copyright case, which was released in May of this year. So before I get there, a little bit of background. Some of you will be familiar with Canadian developments in fair dealing. I think Canada's jurisprudence has been at the leading cusp of developments in this area for the past 15 to 20 years. Of course, as a Commonwealth country, Canada's fair dealing defence was inherited from the UK from the 1911 Act that had famously or infamously codified fair use and had kind of crystallised it into a narrow exception for a limited number of purposes. That were, I'm hearing a translation, is that okay? That were a limited number of purposes that were rigidly interpreted by the courts. So Canada's fair dealing doctrine was evolved from the 1921 case. It followed, the Canadian courts followed suit with rigid interpretations for almost, for the 100 years that followed since 1921. For most of those, there was no successful fair dealing defence in the Canadian courts. But this changed dramatically, basically at the turn of the century. So most notably in 2004, the Supreme Court in CCH recognised that fair dealing was a user right, that it was an essential part of a balanced copyright system, that user rights are not just loopholes, that they should be given a fair and balanced reading and not unduly constrained. Then we had in 2012, 5 cases before the Supreme Court that were really all an effort by the copyright collectives to get the court to kind of step back from this position, certainly on user rights, and instead the Supreme Court really doubled down. So for our purposes, especially with regard to education, the Alberta and Access copyright case is interesting. It held that teachers making copies for students were engaged in fair dealing. Importantly then, all of these developments happened on the basis of the same old statutory language that we had inherited from the UK fair dealing defence. Then in 2012, we also had statutory amendments. These added education to the list of permitted purposes alongside parody and satire. So predictably, at each stage here, there was really a backlash against these developments, right? You had lobbyists, publishers, copyright collectives from Canada and around the world wanting to certainly rewind the 2012 amendments, arguing that education should be removed from the list of permitted purposes, that its addition combined with the Supreme Court jurisprudence had emboldened educational institutions who are now engaged in rampant infringement and harming Canadian creators, Canadian publishers. But the real change wasn't the addition of education to fair dealing in 2012. The real change had come about 10 years before that through a judicial reimagining of copyright's purpose. So back in 2002, in the Taberge case, the Supreme Court had described copyright's purpose as a matter of balance. Rather than just protecting authors, it was to achieve a balance between creators' just reward and the public interest in the encouragement and dissemination of works. The court insisted back then, authors' rights are not unlimited, that society as a whole has an interest in the proper utilization of works. And from this, it naturally followed that both owners and users have rights in the copyright scheme. And so limits and exceptions are a vital part of its operation. Now, a few years back, I was beginning to caution that copyright in Canada was at a crossroads, that perhaps fair dealing had had its heyday, had reached its zenith in 2012, and maybe it would be reined back into line by the powers that be. So I warned that user rights rhetoric was not enough perhaps to stop the pendulum from swinging back, that user rights could be read narrowly, they could be evaluated sort of individualistically, they could be trumped in a balance by weightier rights, perhaps property. And sure enough, we saw at Canada's Copyright Board repeatedly refusing to make real the limits on owners' rights that would seem to flow from Supreme Court jurisprudence. Lower courts were finding against fair dealing in judgments that resembled those of the 1990s. Users, libraries, educational institutions were understandably reluctant in this context to actually exercise their user rights for fear that this pendulum was going to swing back and hit them, which brings us to the York University case, which really, I think, encapsulates these tensions. And I think it's fair to say that whatever was ultimately going to happen in the York case would spell the future, the foreseeable future of fair dealing in Canada. So a lot of people, myself included, were very worried that this would effectively undo the 20 years of progress that we had seen in Canada towards a balanced copyright system and the recognition of user rights. So some information just about the York case. Access Copyright is a collective society that licenses reproduction rights in literary works. And for many years, Canadian educational institutions, including York, had paid Access annual fees that would permit limited copying of works in its repertoire. That relationship broke down when Access proposed increases in the fee for full-time students from under $4 a student to $45, which would have been an annual fee for York alone of over 2 million Canadian dollars. So in July 2011, York opted out alongside several other universities. And then Access, of course, sought to enforce this tariff, arguing that York was obliged to pay, and York argued it wasn't bound by the tariff without its consent, and it counterclaimed for a declaration that any copying that was done within its fair dealing guidelines for faculty and staff would be covered or was covered by fair dealing. So suffice it to say, basically until it got to the Supreme Court, the fair dealing case was not looking good for York. Right? At the trial division, in a hugely problematic judgment, it was held that the tariff was enforceable and that neither York's fair dealing guidelines nor its practices were fair dealing. The guidelines were said to be arbitrary, not soundly based in principle, an attempt for the university to get for free what it used to pay for. And then on appeal to the Federal Court of Appeal, the court agreed with York that the tariff was voluntary and couldn't be enforced on users. And that was a judgment that basically employed step by step the analysis of our friend Ariel Katz. But it dismissed York's appeal on the fair dealing counterclaim. So what we had then was a practical victory for the university, right? Access couldn't require payment, but it was still a devastating blow to fair dealing in Canada. The court's analysis sidestepped all of these important Supreme Court precedents. So, for example, a huge part of the fair dealing analysis is whose perspective should inform the assessment of fairness. The trial judge and the Court of Appeal looked at the university's purpose, and they said, you know, they're trying to minimize costs, trying to increase student enrollment, rather than looking at the end user's purpose, the student whose purpose is to study, or I would add the instructor whose purpose is to educate. The court said the institution's perspective is what matters. Another problem goes to the amount of copying. In 2012, the Supreme Court told us not to aggregate all the copies, but to assess the amount in relation to the user's purpose. In the York case, the trial judge pointed to all the aggregate quantity of copying across the university, across all universities, and talked about the millions of exposures that were being given to students, and found that there was nothing fair about the amount of the dealing contemplated by the university. So that's where we were, right? Access appealed the ruling on the tariff, York appealed the fair dealing ruling, a lot was at stake. There was a significant slate of interveners, from authors guilds and music publishers to faculty associations and library organizations. And this is where the story takes a happy turn. So then we had this unanimous ruling written by retiring Justice Rosie Abella, where the Supreme Court issued a decision that, as Michael Geis puts it, removes any doubt that the Supreme Court remains strongly supportive of user rights. So first, it upheld the Court of Appeal ruling that the tariff was not mandatory. Again, citing Ariel Katz, the court held the tariff isn't binding on a user who doesn't accept the license. The access copyright interpretation would allow a tariff to turn into an anti-competitive tool, would boost collective society's power to the detriment of users. And as well, citing Daniel Gervais, nothing in the Act is designed to prop up collectives that have become less valuable to users. So users have this freedom to exercise their rights without being compelled to enter collective licensing schemes. On fair dealing, the issue is now, strictly speaking, moot, right? York could refuse to pay the tariff either way. So we were kind of worried that if nothing really turned on fair dealing, the user rights at stake might be overlooked or could be undermined. Maybe it would have been better just to leave this well enough alone, but the risk anyway paid off. What we got instead was this unanimous affirmation from the Supreme Court of the central role of user rights. The court didn't rule on fair dealing as such because it was no longer a live issue, but it made clear that this should not be construed as endorsing the reasoning of the lower courts, that there were significant jurisprudential problems with those that had to be corrected. And so first, Justice Abella corrected the court's focus on the institutional perspective, saying that with that mistake, the nature of fair dealing as a user right was overlooked. The fairness assessment was over before it began. She said, in the educational context, it's not only the institutional perspective that matters. Teaching staff making copies for students aren't hiding behind their students' purposes. When universities save money by exercising the fair dealing right, this goes to their core objective of education, not some ulterior commercial purpose. The purpose of copying conducted by university teachers for student use is for students' education. Also, since fair dealing is a user right, the amount of the dealing should be assessed based on the individual use, not in the aggregate. And even by extension, the character of the dealing must be carefully applied in a university context, because to find the dealing less fair when there are more students would be discordant with the nature of fair dealing as a user right. And here's the kicker, I'm going to have to quote this in full. At the end of the day, the question in a case involving a university fair dealing is whether those practices actualize the student's right to receive course material for educational purposes in a fair manner, consistent with the underlying balance between users' rights and creators' rights in the Act. Okay, so I love it. But what I love most about the fair dealing passages in the judgment was the work that the court did to locate this at the core of copyright's purpose and the public interest. So again, here the court pulled heavily on academic scholars, myself, but also Michael Geist, Myra Tawfik, Sam Trosso, Lisa Macklem, saying to understand fair dealing requires understanding the copyright balance, that copyright has public interest goals, increasing public access to and dissemination of works which enrich society and provide users with inspiration is a primary goal of copyright. A proper balance ensures that authorial control isn't privileged over the public interest. Ultimately, creators' rights and user rights are mutually supportive of copyright's ends. So yes, I think now for this moment in time in Canada, we can and should declare victory again for user rights in education. And obviously in terms of implications, I see the time, I'll just take one more minute if that's okay. This is not the end of the story, right? It's unlikely that access copyright are going to go gentle into that good night. We can anticipate assignments, subsequent actions brought by copyright owners with standing. They're going to want to relitigate this until we get the answer they want. So we do have to stay vigilant, but I don't think it's the time to be on the defensive anymore. Now is the time to make real the user rights that the Supreme Court has reaffirmed. The Supreme Court has issued its corrective. There is once again fertile soil in Canada for fair dealing to grow and to flourish, and hopefully by extension for the same kind of normative framework to be endorsed and developed in other jurisdictions, especially those that inherited the traditionally narrow fair dealing doctrine, and perhaps even more broadly than that. So I'll stop there and thank you for your time.
I'm not sure, Sean. Did you say I didn't hear anything?
I've disappeared. Am I still there?
No,
yes,
I hear
yes, you are
again.
here, yeah.
Okay, Martin, it's over to you. Go ahead, Martin.
Oh, okay, okay. I was waiting for that signal actually. So, okay. Thanks so much, Sean. Let me try a little screen share because I prepared a couple of slides. So, as already indicated, I will cover two aspects of recent developments in EU copyright law. So on the one hand, a couple of comments on the new text and data mining provisions as a specific type of legislation in the area of research. And then, if time allows, also some background information on cross-border teaching rules that we now have as harmonized rules in the European Union. So these are the two topics, as already indicated. TDM provisions and cross-border teaching. I turn to the TDM part. As you know, or many of you will know, the European Union legal framework is not based on any fair use type or fair dealing type of provision. Instead, we have broad exclusive rights, but on the other hand, we have a closed list of relatively specific exceptions or exception prototypes. To give you one example of the exception prototypes which traditionally have governed policymaking in the area of research, here you see the provision in the 2001 InfoSoc Directive concerning the sole purpose of illustration for teaching or scientific research. So this was the main centerpiece, we could say, of the EU approach to research and teaching exceptions at the level of EU legislation. And as I've already indicated, with the new legislation, and there I'm referring to the new directive on copyright in the digital single market, which was adopted in 2019. But nevertheless, it's still fair to say that it is new because the process of national implementation is still underway. The implementation deadline has passed, but this piece of EU legislation has still not been implemented in all member states. So be that as it may, we have the harmonized rules, and there are additional norms in the area of research, more specifically dealing with the question of text and data mining. I'm referring to two provisions in particular. On the one hand, we have Article 3, which deals with text and data mining from the perspective of the research community. Member states shall provide for an exception to reproduction rights for reproductions and extractions made by research organizations and cultural heritage institutions in order to carry out, in a nutshell, text and data mining activities. So you see very clearly that the whole legislative process and the final result is focusing very much on the research community. Not surprisingly, this focus has triggered lots of criticism. So when you look at Christoph Geiger's recent work, for instance, you see that this particular focus is, I think, rightly so, described as a very narrow, very specific and overly restrictive framework. Why is this? Well, is the focus on research institutions problematic? It depends on what we will see as further interpretations of this. On the one hand, there is an a contrario argument to be made in the sense that if the EU legislator found it necessary to create a TDM exception specifically for research institutions, then this implies that TDM activities in general are deemed copyright infringing in the European Union. So if you are not a research institution, the argument could be made, what you do in the area of text and data mining infringes copyrights and has to be justified in the light of some other exception or limitation, which in some cases could be the long-standing exception for transient copying that we have in Article 5.1 of the InfoSoc Directive. But in other cases, it is much less clear if, let's say, commercial text and data mining could also be covered by some type of exception. Also with regard to the research rules that we now have in Article 3 of the DSM Directive, we see questions arising with regard to public-private partnerships. So what happens when you have a text and data mining project that is carried out jointly by a university in collaboration with partners in the private sector? Then quite clearly the university, the research institution is still eligible for invoking the text and data mining exception, but whether the results are also fully available for the private partner is something that could become a subject of further discussion in the European Union. Having said that there is no specific further rule on commercial text and data mining, is hiding the fact that, well, Article 3 has finally been accompanied, and this was a provision that entered the arena at a relatively late stage in the policymaking process. Article 3 has been complemented by Article 4, which is much broader, a general limitation of copyright for purposes of text and data mining. So this is something which applies to all types and all parties who are involved in text and data mining, generally refers to reproductions and extractions of lawfully accessible works for the purposes of text and data mining. But then the whole thing has been inherently limited by a further provision in the same Article 4, which says the copyright limitation no longer applies the moment the rights have been expressly reserved. So there is an opt-out opportunity, you could say, for rights holders if they find that their materials that are available should not be used for text and data mining, then they can expressly reserve their rights and this copyright limitation will no longer apply. And this opt-out mechanism, of course, is subject to criticism as well, because you could say the EU legislator gives with one hand a broad text and data mining exception, and on the other, with the other hand, it takes it away again by giving copyright owners a veto right about this specific type of research. So when we look at this solution in a bit more detail, there are further questions that I find interesting and that will certainly lead to further discussions in the future. So one question is, what does machine readable mean precisely? So back to the provision, you see that right holders can expressly reserve their copyright in an appropriate manner, such as machine readable means. So machine readable has also entered the stage at a relatively late moment of the policy making, and there was a shared hope between the high-tech and content industry that there would be a shared standard with regards to machine readable, perhaps some specific type of robots text or some other type of programming of websites and digital resources that would make it easy to communicate about the status of source material. But from a copyright perspective, of course, this raises the question, is there an obligation, a legal obligation for copyright holders to comply with a specific technical standard if such a standard ever arises? Why is this such a relevant question? Well, we have the prohibition of formalities in copyright law. The enjoyment and the exercise of copyright shall not be subject to any formality. This is what we read in Article 5.2 of the Berne Convention. And you could say this could be a showstopper of any future initiatives to establish a shared standard for communicating about the rights reservation and making this a legal obligation that fully applies to copyright owners. So can non-compliance with a certain standard be defended in the light of the prohibition of formalities? We don't know yet. There's also a recital in the new legislation that says that the copyright holder should also be able to use other means of indicating a rights reservation, for instance, in the general terms that accompany a website and so on. So the status is a bit unclear. What I find, as I said, interesting is the question of prohibition of formalities and whether we really have to be worried about this, which brings me also to a point of alternative solutions that could have been imagined and that could perhaps inform policy making in other regions like South America, for instance. And there, of course, when we look at it from a broader perspective, a further element that plays always a very important role in EU policy making. A further element enters the picture. So I showed you already the equation here that we have in the European Union: broad exclusive rights, closed list of specific exceptions. But then, as you may know, in EU law, these exceptions on top of all the other obligations are subject to scrutiny in the light of the three-step test that we know from international copyright law. So traditionally, one of the questions that always arises in an EU context with regard to copyright limitations and also internationally is the question whether there is compliance with the three-step test. And if you are interested, this is a paper that I wrote a couple of years ago without knowing about the TDM provisions that would sooner or later become a reality in Europe. But in this paper, I reflected on the question whether embargo periods, opt-out formalities, and so on could actually help to ensure compliance with the three-step test. So if you're interested in a bit of background reading, then perhaps this could be an interesting paper. With regard to text and data mining, I think the question is a more fundamental one. Does text and data mining fall under the international copyright rules and under the three-step test at all? And I'm saying this, and I guess we will hear a bit about it also from a Japanese perspective in the next talk. The question is, of course, whether this is a type of use that qualifies as something relevant to the three-step test at all, in the sense of requiring a limitation or exception in the three-step test sense at all. Why am I asking this? Text and data mining is very different, as we already know from the fair use decisions in the United States, very different from traditional consumptive, entertaining types of use. So in the European Union, writers like Alain Strovel, for instance, have asked the question whether the use of a work for text and data mining purposes really qualifies as a relevant type of use of a work as a work. And with this formula, the question then is raised whether this is a non-consumptive, purely analytical type of use that falls outside of the traditional copyright paradigm altogether. Well, how is this relevant to the three-step test? Well, I think, but I haven't reflected a lot about it, but I think that there is an argument to be made that the whole question of text and data mining is something that is outside the traditional copyright acquis, and as such has never been covered by the minimum rules that we have in international law. So if you do and take the steps like the European Union legislator has done, and you provide for a specific limitation, indicating that text and data mining falls in principle under the copyright rules that we have, then you are busy doing something that is a TRIPS plus, Berne Convention plus, WCT plus element. And as a plus element, you are free to regulate at the national level as you wish, because you would also be free to say that text and data mining does not fall under copyright altogether. If that's the freedom that you enjoy at the national level, then any type of exception that you still impose on users is a TRIPS plus, WCT plus element, and is something that is permissible whether it complies with the three-step test or not, because you would also have been free to leave this whole area out of the harmonized copyright space. So that's the comment I wanted to make in the light of EU developments on text and data mining. Actually, I don't see any time indications because I have a screen share. I simply assume that I have 1 or 2 minutes left for also say a couple of words about the new teaching rules that entered the EU acquis with the DSM directive. I think the important element there is a cross-border element. When you look at Article 5.3 of the DSM directive, you see that there's quite an innovative, I would say, country of origin solution, saying that the use of works for the sole purpose of illustration for teaching, that's the traditional illustration for teaching starting point that we also find in the Berne Convention. So if this illustration for teaching is done through secure electronic environments, so here it becomes interesting because it addresses modern teaching environments with students perhaps in several EU member states and other countries. So if it takes place electronically via a secure environment, and it is undertaken in compliance with the provisions of national law adopted pursuant to this article, that's a further important element. It means that at the national law, in the national law of EU member states, there is a basis, an illustration for teaching limitation that is in line with the harmonized EU rules. So in all EU member states, there is a basis for permitting this illustration for teaching use. So if this is all fulfilled, then the act of sharing works in this teaching environment shall be deemed to occur solely in the member state where the educational establishment is established. So in other words, we apply a country of origin principle to say that the rights clearance only has to take place in one member state, instead of imposing an obligation on educational institutions to clear copyright in all countries where at the receiving end, students may have access to these teaching materials. The important question then again, from the broader perspective of new solutions for policymaking in the area of teaching is, of course, whether this is something that could be applied more broadly, perhaps even as a model for international policymaking. Obviously, the Marrakesh Treaty comes to mind, where we also have provisions saying that special format copies for print disabled persons should be exchanged between, or well, should be available for sharing between countries parties to the Marrakesh Treaty. Again, I think this is a promising solution, comparable to the country of origin approach that we now have in the area of cross-border teaching in the European Union. But there is, of course, one substantial prerequisite for these type of solutions. Also in the Marrakesh Treaty example, there is a harmonized copyright limitation, or several copyright limitations, which the Marrakesh Treaty provides for in that case, that creates a harmonized framework in all countries participating in this type of regulation of copyright limitations across borders. So we see as a common theme in the EU solution, also in the Marrakesh solution, that a country of origin approach that allows sharing of resources made available via copyright limitations is possible, is conceivable. But there seems to be a need for a shared common ground, a shared body of copyright limitations to really make this happen and get approval for these type of solutions. These are my two comments that I would make based on recent developments in the European Union. So thanks for listening, and perhaps we have time for discussion. I would be happy to hear your questions.
Sean, we aren't listening to you. Please wait a minute. I will able to you.
I couldn't hear you, but can I start? Can you hear me? Okay. So if I am allowed to start. So first of all, I like to thank you for having me today. Let me share my screen. Okay. It's a great pleasure to be able to talk to you today. So I'd like to talk about the Japanese new unique flexible copyright exception, focusing on the provision for exploitations not for enjoying, and the justification for that. So as you may know, Japan is one of the civil law countries. So the Japanese Copyright Act has no general clause on copyright exceptions. But there was a long discussion whether to introduce a general clause on copyright exception in Japan. Actually, my personal proposal at that time was to add a small basket clause at the end of the existing catalog of enumerated specific provisions on copyright exception. However, the Japanese government decided not to introduce a general clause, instead introduced the unique flexible 3 provisions on copyright exception in 2018. So today I'd like to focus on the copyright exception for exploitations not for enjoying, which allows an exploitation of a work that is not aimed at enjoying or causing another person to enjoy a work. So this slide shows Article 34. Based on this provision, it shall be permissible to exploit a work by any means to the extent deemed necessary, where the exploitation is not aimed at enjoying or causing someone to enjoy a work. So you may be wondering about the meaning of enjoy. But as you can see, this provision has 3 items, which are examples for an exploitation not for enjoying. So, and the typical one is text and data mining, as provided for in item 2. So as you know, TDM exception plays an important role. It is now one of the major topics of heated discussions in the field of copyright law. So let me introduce the Japanese TDM exception. The Japanese TDM exception was first introduced in 2009 and extended in 2018. So to tell the conclusion first, the Japanese TDM exception is the broadest explicit provision all over the world. So let me point out some features compared with the European CDSMD Directive. First, the Japanese TDM exception is applicable to not only non-commercial scientific research, but also commercial TDM activities. On the other hand, the UK TDM exception only applies to the analysis for the sole purpose of research for non-commercial purposes. And under the CDSM Directive, as Martin mentioned already, TDM activities, even for commercial purpose, can be allowed, but right holders can opt out for that. Under the Japanese law, right holders cannot opt out. Second, in terms of allowed acts, under the CDSM Directive, reproductions are allowed. On the other hand, under the Japanese Copyright Act, it is permissible to exploit a work in any way to the extent considered necessary. That means an exploitation other than reproduction, for instance, the distribution and communication to the public of a training data set containing copyrighted works, can be permitted insofar as it is conducted for another person's text and data mining activities, and to the extent considered necessary. Third, no lawful access requirement. Under the CDSM Directive, it is allowed to use lawfully accessible works. On the other hand, the Japanese TDM exception has no such requirement. Therefore, even if you download a number of movies from an obviously illegal website, you are still allowed to copy them for the purpose of text and data mining. Additionally, through the amendment in 2018, not only computer-based data mining, but also non-computational data mining is permissible under the Japanese law. So in sum, text and data mining is almost totally allowed in Japan. I would say that the Japanese TDM exception is the broadest explicit provision all over the world, as far as I know. It is quite helpful for machine learning. That's why I usually say that Japan is a paradise for machine learning. So let me take an example. If you train an artificial intelligence using all of the Disney movies, this AI might be able to generate a new movie in the style of Disney. It is true that TDM activities can entail machine reading of copyrighted works, and it is regarded as a reproductions of works in the meaning of copyrighted law. But such machine reading is not aimed at enjoying the work or causing another person to enjoy the work. Therefore, such machine reading of works is allowed under this provision. Then, as a result, such machine, you are allowed to sell such a new movie generated in the style of Disney without the authorization of the copyright holders. Even though the Walt Disney Company would like to opt out, you are still allowed to use the Disney movies, even for commercial TDM activities under the Japanese law. So another example is an exploitation as needed in experiments for the technological development as provided for in item 1. For example, when an IT company researches and develops a data compression technology used for movie player in a smartphone, it would be helpful to experimentally copy a cinematographic work in order to evaluate the quality of the data compression technology. So this reproduction is just for experiments, and it is not aimed at enjoying the work or causing someone to enjoy the work. Accordingly, such exploitation is allowed under this provision. Furthermore, I'd like to emphasize, as you can see, the main paragraph of this provision stipulates the following case or other cases. That means this provision allows not only the particular exploitations in 3 items, but also other equivalent exploitations not for enjoying. So you can say that this provision has a basket clause. One example is reverse engineering of computer program. Even if you copy a computer program for reverse engineering, it is just for analyzing an algorithm. It is not aimed at enjoying the functions by executing the computer program. Accordingly, such exploitation shall be allowed under this provision. So that was the flexible copyright exception for exploitations not for enjoying. However, you may be wondering why an exploitation not for enjoying is allowed. What is the justification for the copyright exception? Let's move on to the next section. I cannot go into detail today, but the basic idea behind this provision is that copyright is a right protecting only an interest in the inherent exploitations which are aimed at enjoying or causing someone to enjoy a work. If an exploitation of a work is aimed at enjoying or causing the public to enjoy a work, such as book publication or movie screening, copyright should cover such exploitation. On the other hand, if an exploitation of a work is not aimed at enjoying, such as text and data mining, copyright doesn't need to cover such exploitation. Therefore, the copyright exception for exploitations not for enjoying seems to be based on the idea of the internal limit to the scope of copyright, rather than the external limit to copyright as a result of striking the balance with other fundamental rights, such as the right to research. Some of you may feel strange, but interestingly enough, some scholars in other jurisdictions try to exclude TDM activities from the scope of copyright based on, for example, the theory of a use as a work, as Martin already mentioned too, the concepts of reasonable exploitation, a redefined scope of exploitations, or non-expressive uses. I have to skip some slide on those discussions, but what I'd like to emphasize today is that a little similar idea can be seen here, that TDM activities are beyond the inherent scope of copyright, since TDM activities do not prejudice the copyright holders' interests that are to be protected by a copyright law. So that brings me to the end of my presentation. Let me just briefly summarize my talk. The Japanese government introduced the unique flexible copyright exceptions. In particular, the copyright exception for exploitations not for enjoying allows an exploitation of a work that is not aimed at enjoying or causing another person to enjoy a work, such as text undermining. In fact, the Japanese TDM exception is probably the broadest explicit provision all over the world. So I can recommend you introduce such a broad explicit TDM exception in your jurisdictions. Of course, the important problem is the justification for this copyright exception. But considering the basic idea behind this provision, it is based on the idea of the internal limit to the scope of copyright, rather than the external limit to copyright as a result of striking the balance between, with other fundamental rights, such as the right to research. Nevertheless, I believe that this copyright exception can consequently promote the fulfillment of the right to research. I hope that the recent development in Japan would be meaningful for you. Thank you all very much.
This is super useful. Thank you very much. And hopefully I'm back with us. Am I being heard? Can I be heard? Okay, good. Sorry for the technical difficulties. I think I've been in the interpreter for the first half of this meeting today. But I've been told by the host that we can take another 15 minutes so we can have a little bit of discussion between ourselves and with the audiences. So I think people from the audience, if you want to put text in the chat or in the Q&A, we'd be happy to try to address it. But let me offer a couple points of discussion maybe to get us going. So I felt like that last argument very much had interplay, Martin, with the way you were describing the TDM exception as outside of the acquis. And Ueno has mentioned, some of the writings, Thomas Margoni and others, that I think raised concerns that by providing an exception, you're actually suggesting that TDM activity is protected. So I wonder if we could have a little interchange on that. Do you think, Ueno in Japan, do you think the breadth of the non-expressive use exception reinforces the idea that it's not protected, or does the provision of that exception imply that TDM is protected and needs an exception. And Martin, you know, how does the argument play with your conception as well? Do you believe that ultimately TDM needs to be perceived as kind of outside of protection in the first instance? And does the EU's provision of an exception work against that? Or do you find that your kind of outside the key argument can continue despite the provision of that exception?
So should
yeah,
I
Martin,
start?
why don't you go first? Yeah.
Or would you like Tatsuhiro to start?
Whoever wants. Go ahead, Martin. Why don't you react to the Japanese case, for instance?
Yeah, actually, I mean, as I already indicated during my presentation, I thought that considering the developments in Japan, Tatsuhiro would also touch upon this question: is it inside or outside the traditional understanding of what copyright really covers? And well, I mean, I stand to be corrected here, but as I see it, the Japanese rule and practice, and in his recent Gruer article, Tatsuhiro also reflects a bit on more traditional statements back in the 60s when the current Copyright Act in Germany was introduced. There were also statements made at that time that copyright seeks to protect the enjoyment of the work and not necessarily other types of use that we see now in the TDM age with purely analytical and systematic reproduction of copyright work, but not for the purpose of enjoying those works. So I see this as a confirmation that what we have in the international copyright acquis is something that does not cover text and data mining from the very beginning. And then what the national legislator does is basically a TRIPS plus or WCT plus rule. I saw that in the Japanese legislation. It also says that the whole limitation does not apply when it unreasonably prejudices legitimate interests of the copyright owner. So I think this is a play of the Japanese legislator with rules that come from international law, but I wouldn't see this as a statement saying that there is an understanding that this falls under copyright law as it is harmonized internationally. And also, as the European Union legislator has done, is a decision of the European Union legislator to actually give the impression that this falls under copyright. But at least from an international perspective, there would have been more room for saying it falls outside the scope of traditional copyright, and it can be regulated in a much more open-ended way, like, for example, Japan has done. So that would be my understanding of the current situation.
And Tatsuhiro, you focus your presentation on what I also see as kind of the broader of the two potential TDM exceptions, the one that says basically anything, any kind of exploitation, as you mentioned, using that very broad term, it's not for enjoying the expression of the work is exempted. There's another exception for information analysis as well. And so do you see the enjoyment exception as being broader or more useful than the information analysis exception that Japan also provides?
I'm sorry, could you refrain again?
I believe Japan also has and I can pull it up in just a second, also has an exception for information analysis.
No.
Separate.
The TDM exception I introduced today is the provision for information analysis. So you mentioned it's the same provision, Article 34, Item 2. So which is a copyright exception for information analysis. So which I call it our TDM exception. So it's the same provision.
Okay, let me try to pull up the other one I'm referring to in just a minute. And is your interpretation of the exception and in its breadth that it's an acknowledgement that those issues shouldn't be protected by copyright in the first instance. It's a definition of the outer limit of copyright.
Do you mean that, or the TDM exception, TDM activities is beyond the scope of copyright?
That all uses that are not for enjoyment of the expression, so all non-expressive uses. Do you interpret that exception as being an instance of Japan deciding that those uses really should never have been covered in copyright in the first instance?
Yes, and the new copyright exception for exploitation, not for enjoying, allows in general an exploitation not for enjoying. So, and the TDM activities is one of the exploitations not for enjoying. So the copyright exception for not copyright exception not for exploitation not for enjoying, it's quite flexible and yes, very broad. So yes, so under the Japanese law, such exploitation would are considered as outside the copyright, the scope of copyright. So
can I jump in, Sean, just to mention?
Jump in, Carys.
Thank you. Because we've just, people might have seen shared on Twitter, I think yesterday by Pascal Chapdelaine, we 15 scholars have just submitted submissions to the Canadian consultation about text and data mining exceptions. And in that document, we actually, we cited the Japanese example, and we began with the proposition that the reproductions, at least for this purpose, and other necessary acts for the purpose of TDM did not and should not implicate the legitimate interests of copyright owners in the first instance. So I think that position is very much in line with what Tatsuhiro and what Martin have been saying. And we also suggested that having a separate specific exception that would make clear and remove any doubt about what was within the scope of that was advisable too, to try to create this space. There's one, I think, just conceptual issue that's worth flagging about this, which is, I think, when it comes to sort of advocating for this position, it's certainly easier to say, you know, we're not advocating for taking away from copyright owners any rights that they in fact have to control particular uses. That this is about clarifying precisely what the scope of the copyright owner's interests already are. And so that makes it, I think, a good sort of political approach for clarifying that TDM uses should be outside of the copyright owner's control. But I do also think that if we have a real commitment to the user rights language, and going back again to the language of the Canadian Supreme Court, we make clear that the owner's rights do end where user rights begin. That fair dealing and other exceptions in the public domain do in fact define the limits of the copyright owner's control. And so I think it's conceptually worth noting that if it is a positive user right, then by definition, that right or that exception or limitation in the Act does define the outer limits of the copyright owner's rights going forward. And so there's just, you know, there's some interesting sort of rhetorical twists that are done to have both understandings that play at the same time. But I certainly think that this is the appropriate response, is to say it's not something the copyright owner should be able to control in the first place, and certainly with an exception that's outside of the scope of their rights.
I don't know if there's other countries that have clear, and Christoph Geiger has an interesting point within the text that I think clarifies it further, right? Like, so if you define your TDM permission through an exception that potentially you may be applying a 3-step test to the outer bounds of that permission, where perhaps if you defined it instead through a limitation on the scope of copyright in the first instance, for instance, a definition of what it means to be a fact or what it means to not be an expression or to not be subject to fixation, then you might not come within the 3-step test within your domestic or regional situation. I think, Martin, your argument is none of it should come within the 3-step test.
Yeah.
Burn, right?
Actually, I think just a quick comment on that one. I think that we have become used to applying the 3-step test to whatever type of rule prevents copyright owners from exercising a right of control over use. And then we always think we have to apply the 3-step test. But traditionally, there are more examples of inherent limits of rights. If you think about the exhaustion or first sale doctrine, as you would say in the US, which is an inherent limit of the right to control the distribution of individual copies. And as far as I know, never has anybody made a convincing argument that this would be subject to the 3-step test. And it would not make sense at all. If you apply the 3-step test to the first sale doctrine, then it's very difficult to argue that it complies with the 3-step test. So there are these types of use that are carve-outs that do not fall within the copyright monopoly in the first place. But it can be very difficult to find the concrete limits of that. I think in the cases that Tatsuhiro has explained, he used a very clear example by saying, if you analyze Disney movies to make a further movie in the style of Disney, it falls under the exception. The line is more difficult to draw when you say you analyze scientific texts which are made for research and analysis in the first place. Then it's more difficult to apply the TDM exception, because you would still have to say, yeah, but TDM is an automated analytical process that does not really look into the text in the sense of a human being trying to understand and follow the text, which I think is the idea of enjoyment when it comes to scientific works. So I guess there is room for arguing that TDM is also possible in the case of research materials like scientific articles and books. But I think that would be a very difficult case to decide. I don't know if this is something which in Japan or in the Canadies discussion has already played a role, but I think that's a hard nut to crack in that area.
Do you want to engage that, Tatsuhiro? It comes down to what enjoy means in Japan's law, right?
So asking about sorry, I didn't follow your question.
It may have come too fast. Yeah, I think Martin was making the point about if you say the exception is about exceptions for uses that aren't to enjoy the work. If you relate that to the purposes for which the work is produced, then does it have a different meaning to enjoy a movie versus to enjoy a research material? So when you're text and data mining a research material for the purpose of research, are you enjoying the content of that material?
No. Under the Japanese law, and the enjoy has the very raw meaning. If you analyze a massive amount of, for example, medical research or articles, and you can derive the new knowledge from the massive amount of medical articles. So, for example, you will be able to know a new method of treatment. So that would be considered as not enjoyment under the Japanese law. It is totally allowed in Japan. under this copyright exception. So if you sell the massive amount of an article and to the public, so the public would enjoy the work. So it is not allowed. But if you analyze the medical researches by using computer or without using computer, it would be allowed under the Japanese law. That's my point.
Maybe shifting a minute to some of the educational questions. Martin, I was wondering whether you had a reaction to Carys's description of the Supreme Court as deciding in the first instance that the tariffs did not apply to the schools that hadn't accepted them. Do you think that a EU court would come out very differently? Is that a step of the analysis that would be more plagued in EU, or did you have any reaction to that?
Well, I'm not so sure if we would have exactly the same scenario in an EU context. So, I mean, we have very active collecting societies, and in many laws, the educational provisions, which could be copying for educational purposes, making copies available to library users under certain circumstances and so on. Very often this is already covered by exceptions and limitations, but those exceptions and limitations require the payment of equitable remuneration to collecting societies. So it is an area where we have a money stream, but we don't have a right for collecting societies to say you need individual permission. So yeah, in that sense, I'm not so sure if we arrive at a comparable scenario very often in an EU context, so that you have a collecting society declaring a certain tariff applicable. If that happens in the EU, it's very often under an existing copyright limitation that requires the payment of a certain remuneration. And then it's clear, if you invoke that copyright limitation, then it's clear that you are bound to actually pay this price. On the other hand, the collecting society is not entirely free to set the price because it's a lump sum payment under a copyright limitation. So as I understood it, the enormous rise of remuneration that was a starting point in Canada for libraries to say, or universities to say, we no longer can afford this, is something that you wouldn't see so quickly arising in the European Union, I think.
Jump in, Carys, yeah.
Yeah, so it is true, when I was thinking about this, I was wondering to myself, and this is maybe Ariel Katz would be the person to answer, but how transposable this part of the judgment is to other contexts. And I share your sense that maybe not always, because so much of it was tied up with the sort of legislative history and the sort of bureaucracy around collective administration in Canada and the role of the Copyright Board and so on. But I do think it's worth stressing maybe that it didn't occur to anybody to argue this in Canada either until Ariel decided to really look into it and to do this work. And then he and Howard argued it in another case in 2016 and got some traction. And so the notion that it's at least worth being sort of imaginative about this and thinking about how to protect user rights and the risk posed to user rights and freedoms by copyright collectives, especially when there's a lack of transparency and a lack of accountability and a lack of competition. I think at least flags that this is a potential avenue for exercising some of those rights and maybe pushing back against some of those ingrained practices, certainly when they become unduly onerous by the copyright collectives. Now, I know there's been a lot more work done in Europe to ensure transparency and accountability of the collectives, and we're behind in that work in Canada. But even the Copyright Act review that we had recently recognised that this was an area where more still had to be done. And so it's almost putting together this package of thinking about regulating the copyright collectives and their role in the system, thinking about user rights and the limits of copyright in order to achieve the sort of balance that we need across the system, and putting these pieces together.
One of the major themes of this work, dating all the way back to the original Global Congress and the Washington Declaration, is that user rights frame and teasing out what it means to be a user right as opposed to an exception. Christoph notes in the chat an instance of that shift having real legal weight. So Article 117.9, I assume that this is a DSM of 2019, I think. In particular, member states shall ensure that users have access to court or other relevant judicial authority to assert the use of an exception or limitation to copyright and related rights. And there's a similar ruling in the United States giving EFF an affirmative right to bring a fair use case against, I believe it was Viacom, for taking down content in which it didn't have a right to take down because of that fair use right. So it's a slow shift, but I think there are interesting examples where conceiving users' rights as users' rights can also lead to different ways of thinking about how they could be enforced.
Yeah, and I think it's fair just to say that in Canada, we have the language of user rights, we have the concept, it's doing its work at the Supreme Court, but we don't have these moments that sort of make real that positive enforcement. We don't have rules that protect sort of mandatory limits and exceptions from contractual override or technological override. And so there's a lot of work still to be done on the ground to, I think, make the promise of user rights real in these contexts and in these sort of procedural ways.
Yeah, I mean, some of the work we're doing in the Right to Research project is engaging human rights and constitutional scholars, including Christoph Geiger, who appears to be in the room, to tease that out. And when you start thinking about copyright as the exception instead of the rule, as copyright as the affirmative government act which steps into the public domain, if you will, or whatever the regime was prior to copyright, then that does trigger this kind of free expression thinking, right to education thinking, right to research thinking that demands exceptions and demands limits on that government intervention into a prior unregulated space and can give vibrancy to that concept. So we just have I was going to say 1 minute, 2 minutes, but if either any of the speakers want to have a final comment, you are welcome. Carys, you want to start?
I saw a question from Andres earlier just about whether there's going to be some shell shock amongst user institutions, educational institutions as a result of the lower court rulings anyway. And I think the answer to that, unfortunately, is yes, that it was kind of the fears realized right up until the Supreme Court case. And so I think we do have a lot of work to do to try to reassure those who need to sort of flex their fair dealing muscles that they're safe to do so. And I think that's work that we have to do sort of on the ground to really enjoy the benefits of this victory for this moment.
Super. Martin.
Well, I mean, in addition to what we have just discussed, there is also another perspective for the European Union now, I think. It is clear that in the area of text and data mining, the European Union has taken a different path in comparison to Japan, for instance. So basically, copyright owners in the European Union have a veto right and can opt out. So we face other questions in practice, like if licenses are needed for this, how do you ensure that licensing infrastructures are not too burdensome and that licenses are available at relatively low transaction costs and so on, which can also be an important second step if you don't have a copyright legislation which from the very beginning says that this falls outside the traditional area of control that copyright owners should have. So that's perhaps a further addition to our discussion.
Tatsuhiro, final word?
I have one thing I didn't mention today. The Japanese TDM exception is quite broad, but we have no provision on unenforceability of a contractual provision contrary to copyright exception. So that means contractual overrides. So in Japan, under the Japanese law, contractual override is allowed, and technological override is also allowed. So that's a difference between the EU law. So I think that's a problem. And so I talked about the positive aspect of the Japanese law today, but to be honest, it is a little complicated. So that's the words I'd like to say. So thank you, Fumer.
So end on the complication. Thank you. Thank you to everybody for joining us. I did put a different room in the chat, and if you'd like to come, we can spend just a few minutes informally. I'm told this room is going to automatically shut down any minute, so I might be able to finish my sentence, which is great. But if any members of the audience would like to chat with us face by face, I will open that Zoom room in just a minute. So to all my panelists, Carys, Martin, Tatsuhiro, thank you very much. This was a great and informative session, and it was great to see you. So with that, I will close this session and welcome you if you have a minute to pop into the other